So without much further ado, I would like to give the floor to Lord Goldsmith to chair this amazing panel, and well, the floor is yours.
Nikos, thank you very much indeed. It is a great pleasure and an honor to be chairing this panel. It is a great panel, not because of my presence, but because of the presence of everyone else, and particularly Meg, of course. So the way we're going to run this is Meg will address us first, and we look forward very much, Meg, to hearing what you have to say. I don't really need to introduce her, but she's got the great ability and the great credit and great experience of having both seen the side in government and then through the work that she's done in ICSID, understanding how this current system works and making it work. So what we will then do is I'll then call on the other panelists in some sort of order, which I'll randomly make very clear later. We've talked about it before, who will have some comments, but the idea is that we will leave good time for audience questions and audience participation. So I don't want to take up time, therefore, introducing people. You've got people's bios, if you don't actually know them, but you've got their bios in the program. So can I start by asking Meg if you will please address us?
Absolutely, I would be delighted. Thank you. I am delighted to be here. This is my first time at an EFILA conference. And when Nikos called and said, would you give the keynote, I said yes, but I won't mention, it doesn't have to cover three things: the word acmea, the word or phrase multilateral investment court, and the word appellate body. So I said, if you think there is anything else left that I could talk about, then I would be delighted to be here. So I'm absolutely thrilled to be here. And Nikos did come up with a much better, much more interesting set of topics. So I thank you. I also think I should perhaps apologize a little bit because what I'm going to say overlaps somewhat with what my colleagues have just said in the last panel. So in some respects, I do apologize, but I have to say it's given me great confidence to hear experts like our prior panel saying the things they did, because it makes me feel that ICSID is on the right track in terms of this amendment process with the alternate dispute resolution mechanisms. So it's given me some comfort, and I hope that it doesn't mean this is more boring for you, but I'm very, very pleased to have heard what we heard in our last panel. I've been asked to speak, as you know, about ADR in investment and the role of complementary mechanisms. And I have to say that as I thought about this topic, I thought it was in many ways almost ironic that in investor-state dispute settlement, when we talk about alternate means, we indeed mean alternate to arbitration. Because certainly when I grew up in my early legal career, arbitration was the brand new thing, and in many respects, the ADR mechanism. So if nothing else, perhaps it proves that in investor state, we come at things from the totally opposite perspective. But I do find that kind of ironic. And then to add to the irony of all of it, I think it's kind of amusing that now, here we are, the newest, latest idea we're talking about in investor state arbitration, courts and appellate bodies. So I guess all I can conclude there is go figure. I would, though, like to talk about ADR mechanisms in investor-state arbitration. It is one area where there's a huge amount of enthusiasm, and both states and investors and their counsel are extremely interested in really giving this a try. I think it's fair to say that while we have a little bit of experience, we really don't have that much experience. So we are at a real starting point with all of it. In many ways, the roots of the ISDS system were in ADR mechanisms. And let me see if I can do this right. Those of you who are students of ICSID will perhaps know that in the early 1950s and 1960s, the World Bank was increasingly asked if it would lend its good offices to resolve disputes between member states and investors in those member states. And indeed, one of the early World Bank presidents, Mr. Black, identified dispute resolution as one of the key mandates for his staff, and he felt that was one of the most important roles the World Bank could play in trying to encourage investment. So it's really nice to see that they started at this place and to see this kind of involvement. In fact, President Black was actually personally involved in a number of cases and personally acted not only with his good offices, but acted as a facilitator, a mediator, and a conciliator in individual disputes brought to the World Bank for resolution. So there is a real history in that. I think the best known examples of this are things like the claims of shareholders in the Suez Canal Company when that was nationalized in 1956. There was a very successful conciliation with French bondholders in the city of Tokyo that you may well know of. And there was a successful mediation of a dispute between India and Pakistan over water flows in the Indus River. And indeed, that's led to a very unique treaty, the Indus Waters Treaty. And that treaty in itself has not only formal arbitral processes for dispute resolution, but a very interesting expert determination process. So all of this thought about ADR was something that was very alive in the early days of the World Bank. I think the World Bank was also able to play a very successful role because of at least 3 characteristics that I would isolate. And I isolate these now because I think they may bear some lessons or be good watch posts for us now as we try to start building this more and more into what we're doing. The first one, obviously, was that it was seen as impartial. And this is something that is absolutely vital to your credibility. And the idea that it was not a domestic system, that it was not more allied with one party or the other, and that its commitment to resolution was to encourage the business relationship and political stability and helping the investment climate was something that gave it huge impartiality and huge ability to come to resolutions. The second one that I think is really important is that the bank has always been able to bring technical experts to the table for dispute settlement. And as you will probably know, the World Bank has a huge number of experts in all sorts of various areas related to development. And these people in the early days in particular were able to play a vital role, not just in let's resolve this one-off dispute resolution, but let's find a solution that's enduring and that takes account of the bigger context that we're in. So I think that's an interesting lesson and one that's perhaps harder to put into our current mediation rules or alternate dispute resolution rules, but that is a really important thing to bring to the table. The other thing, which perhaps is related to the expertise, is that the bank was able to propose creative solutions. Again, not just settling the one-off dispute, but trying to smooth the relationship and keep it as an enduring relationship with an enduring operation that would go forth and get over the dispute resolution. So by the time ICSID was created in 1966, there was very clear recognition of the need for a standing capacity to resolve these investment disputes. And from the start, ICSID offered both arbitration and conciliation. And it will probably surprise you to know that the drafters of the convention actually thought conciliation would be the go-to method of dispute resolution. And in fact, they didn't expect much work out of arbitration. You probably also know that while they did expect that there would be a little bit of work coming out of treaties, they felt that much of the work would come from individual investment contracts. So again, sort of what goes around comes around, I guess, is part of the lesson. In 1978, the World Bank brought forward, or ICSID in particular, brought forward another set of rules which were called the Additional Facility Rules. And those had a set of investment arbitration and investment conciliation rules, which were quite similar to those you saw under the ICSID convention proper. But what they also did, and I think was frankly little noticed by the community, was that they broke new ground and put forward a fact-finding mechanism for disputing parties. So what we have is a very clear history of efforts by the World Bank to use dispute settlement to supplement the efforts to create positive investment climates. And ironically, while there was a lot of creativity at the beginning of the piece, over the years, I think more than 95% of our work has ended up being arbitration, and in particular, arbitration under the convention. On the other hand, we have over the years, and I'm sure all of you in this audience have heard the growing consent and the growing concern about the time it takes to arbitrate, the cost to arbitrate. Is it something accessible in particular to small and medium-sized enterprises, and all of those kinds of issues. And while this is not unique to investment arbitration, it is certainly something that we hear a lot about. So when we began the current process to amend our procedural rules, we knew that one of the things we wanted to try and address and we wanted to bring in was a set of alternate dispute resolution mechanisms. So we began our process with a broad consultation among states, but also a consultation with the arbitral community and with the public at large. And this is something I think that has perhaps distinguished this set of amendments from the others, and probably reflects that we're just in a different world in terms of investor state than we have been in previously. What this ended up with was a set of rules where we had some specific goals, but they mushroomed, and we have now ended up with, I think, what is very fairly the most comprehensive set of proposed rule amendments. And if you don't believe me, I will show you. This is the famous working paper number 3. I show my age by saying it's about the size of a phone book, and the millennials look at me like, what's that? Yeah. But our working method, it's actually been very good and has really, it's really worked well, but it's essentially been to consult, put forward some draft proposals, explain why, what they're trying to achieve, and then have a larger consultation, and next would be working paper number 2. This is beloved working paper number 3, and my goal is not to live to working paper number 520. So I am hoping we are turning the corner. I think we very much are. But this working paper, in particular on mediation, was extremely useful because it spawned a lot of discussion about how do we do this. We haven't got a huge track record. We've had some sui generis type of mediations at ICSID, but this really gave us a chance to see it through and to try and work through some of the best of what we've seen in practice. And we've been very much assisted by some tremendous practitioners, including Mark, who you just saw in the prior panel. As we looked at this and as we talked to parties, what we heard as a consistent message was that they wanted more selection in terms of options. They wanted more and different options. And interestingly, they wanted less procedure, more informality, less procedure, less rules in some respect. And that was an interesting message to us. So what we've ended up doing, obviously, is an update of the arbitration rules, but we have also updated the conciliation rules to make them much more of a modern day type of ADR mechanism. We have proposed a freestanding set of fact-finding rules, and then the freestanding set of mediation rules. And we look at all of this basically as a suite of dispute settlement options. And one of the things that we hope parties will eventually come to use these for or look at them for is not just as alternatives, let's mediate instead of arbitrate, but that these would be tools that could be used at various times, perhaps before the case was formally started as an arbitration, but also in parallel, sometimes perhaps with a stay of one process focusing on the other, or sometimes both of them going simultaneously, or perhaps even at the end of key parts of the dispute settlement. And it's actually been quite interesting to see. We've had a number of cases where liability has been found and parties have stopped the process and have mediated the damages portion, or mediated something that I think is very hopeful, a way for them to go back and start doing business, as opposed to how much is the financial resolution going to be. And that's, of course, what you want from these kinds of rules. So we are hoping that these ADR mechanisms in the amended proposals will work in that kind of fashion, and that the profession will start to use them in that way. So you can imagine, for example, obviously mediating before you go into an arbitration, but imagine having a fact-finding parallel to an arbitration or a mediation, if it's that critical fact that will make the difference. then feeding it into the mediation. And the point here is to have all of this under a single roof so they can be used interchangeably. When thinking about these tools, we also decided that it was best to try and put them really on this continuum, if I could, of binding to non-binding. And if you look at this, essentially you would probably start with the fact-finding and the mediation, and then work up to the more formal mechanism of conciliation, and then get yourself to arbitration. And as you go through this continuum, I think you will see that increasingly it becomes a more and more party-driven process. Increasingly, if it's going to result in sustainable end product, it has to rely less on hard rules and more on the party buy-in, the party confidence in the process. And one of the things that we've said all the way through this is we didn't want to make these too heavy, because at the end of the day, the process had to have both parties as willing participants, or else they should simply withdraw consent and go to whatever is next. So for example, we had a discussion about should we have a challenge mechanism in the mediation rules. And ultimately we came to the conclusion it's really not worth it. If you're at the stage where you can't consensually agree to replace the mediator, and you want to get into a challenge situation, you're probably just spinning your wheels, and it's not worth moving forward with the process. So you will find that a lot of things here that you might find certainly in arbitration rules, but even in other mediation rules or other ADR forms, aren't in this set of mediation rules. Over the years then, we have had conciliation, and I'd like to spend just a bit of a moment on some of the updates that you will see in the conciliation rules. And it is very true, there have only been 12 conciliation cases in the history of ICSID. We've had something over 700 cases, so that tells you a very small order of magnitude, around 3% of our caseload. But I do think that should not be taken as we don't need ADR mechanisms or we don't need conciliation. We also have a very important fact which year in and year out is consistent, and that is that about 35% of all cases resolve before getting to a final award. So you have got at least that much, and I suspect more room than 35%, where there is a chance at some kind of a negotiated resolution among the parties. And so again, providing good tools that will take advantage of that is really important. As you know, the main distinction, of course, between conciliation and arbitration, and certainly under the ICSID scheme, is that conciliation results in a report which gives a recommendation and a non-binding outcome. The mandate of a conciliation committee is to narrow and clarify the issues in dispute and to bring the parties to a mutually agreed settlement. And that mandate has been continued in this set of rules. We also know that conciliation, when it works, is actually quite successful from a time and cost perspective. And indeed, our estimate is that conciliations to date have cost about $185,000 for everything but the counsel fee. We don't know that counsel fee number, but the entire administration, the conciliators, all of that has been in the range of $185,000. And that's a very successful number when you compare the cost of many of the arbitrations. So we think this will certainly make not only conciliation, but mediation quite attractive to the parties, and we're looking to reduce that amount even further. Throughout our conciliation rules, we have put a premium on this reducing time and cost. And one of the other things we've had to look at is this whole issue of confidentiality. And I have to say it is a difficult issue, and I'm of two minds on it all the way through. One of the key things we did was in the revised rules, we said very clearly that documents used in conciliation would be confidential, and very clearly stated that parties could not rely on admissions, settlement offers, or views stated in the conciliation. Obviously, trying to make sure that it is as without prejudice a process as possible so that people will not hesitate to use that process to end up being almost a pre-discovery type of mechanism. So we thought that that was a really useful type of provision to put into the rules. We opted as a default for a sole conciliator, but parties can have 3 conciliators if that's what they would like to do. We kept the traditional mandate of clarify issues and bring about a mutually agreed settlement. And we gave the Commission the ability to make a resolution proposal to the parties at any time, but required them to consult the parties and to offer to do this either orally or in writing. Again, trying to make this as comfortable as possible for the parties. The conciliators cannot force a settlement, and if they recognize they're not getting anywhere, then they simply write the report and say we're not going to be able to resolve the dispute. So again, all of this is geared to making it as accessible as possible and trying to make sure parties don't feel they will be at a disadvantage at the end of the day. In terms of time, we said that there would be a first submission within 30 days after constitution of the Commission, which I think is a relatively short period. And something that I think is a really important innovation in response to some of the comments you've heard earlier today, we are requiring each party to identify a person who comes to the first session who says, I am authorized on behalf of my government or on behalf of the claimant to settle this dispute, and I can explain to you and describe the process we would have to follow. So the idea is to force people to concretely think from day one, if we can get to the right resolution, we have the mechanics in place and the will to do so. And this provision, I think, will be very useful, and we've carried that over into our mediation rules as well. The other important thing is the enforcement side of the house, so that if parties come to a resolution, they can request that the full settlement agreement be appended to the conciliation report. And our understanding and our belief, and we've checked with the people at UNCITRAL and we've read very carefully the Singapore Convention, we believe that this is going to meet the form requirements established by Singapore, and so that will make this something that can be enforced, which obviously is key to the parties and hopefully another incentive to get parties to use this. In addition, one of the things that we have thought of is that if the conciliation is parallel, or for example, if the mediation is parallel to an actual ICSID convention arbitration case, the parties can then append this written settlement document to an award. That award is issued like any other ICSID award, and it then gets the force and the benefit of the automatic enforcement or simplified enforcement under the ICSID convention. So that, I think, is going to be a huge benefit to parties and very much an encouragement to use this process. So these are designed to be concrete and enforceable, workable rules. The next set of ADR type mechanisms we've put is a freestanding set of fact-finding rules. And as you know, fact-finding is a very specific mechanism where a third-party neutral examines a set of facts and makes 1 or 2 fact findings, obviously, as it sounds, on this. And we're used to this much more in the public international law context. I think you've all seen a number of United Nations fact-finding commissions. We know that they can be useful in commercial disputes, but I have to admit that the fact-finding rules under the additional facility at ICSID have never been used. Now, that may be because they got bad PR, and so we'll give these ones much better PR. But I think it probably reflects the fact that they are a very specific type of mechanism, and when you are dealing with investor-state dispute settlement, it is often not just a single fact that's going to make the difference in resolution. It is often applying a set of rules that may or may not be clear. So I'm not surprised that they have not been used. And we did have a real discussion about, is it time just to give up on fact-finding? And we decided, no, we think it is worth, again, at least offer the mechanism. And if parties think it will be useful, at least it will be there. So these are, as I say, freestanding fact-finding rules. And we made the threshold to use them much lower than under the ICSID Convention. So as you know, jurisdiction under the ICSID Convention requires you to have a dispute, a legal dispute between a national of one state and another state, which arises directly out of an investment. And much ink has obviously been spilled on saying what that is. For the fact-finding rules and the mediation rules, we brought that threshold down significantly and simply said any dispute that relates to an investment. We also specifically said this should be applicable to and available to regional economic integration organizations. And the key to all of this and the application of this is consent. And our thought was you don't need a lot of formalities, because if the parties are still not comfortable with the process, one of them will withdraw their consent. So trying to make sure parties were comfortable was the key thing. In terms of process, we have a default in favor of a sole fact finder. Again, parties can opt for more, but the default is one fact finder. And we start with a short written statement, 50 pages or less, and a first session that has to be within 15 days of getting your fact finder. So the idea is that very quickly after you've settled on the identification of the fact finder, you will put forward, here are the basics, and get together with that person and then set out what we're calling the protocol for the fact finding. Again, all of the rules about making this without prejudice and not being able to rely on it later on was there. And at the end of the day, it ends in a report issued by the fact finder with the finding, assuming they can make that finding. So I think in frankness, I don't expect them to be used a huge amount, but I do think there are times when they will be very useful. I think in particular, in investment contract situations, they will be very useful. And I join the speculation of a lot of my colleagues. I expect we will see more investment contract work in the future. So I think the timing is probably ready for this. The last one I wanted to speak to is mediation, and that's probably the most important of these ADR tools and the ones that we have heard and consulted the most on. Again, these are what we're calling freestanding rules, so not attached to the convention and not attached to convention definitions such as legal dispute arising directly out of an investment. We have allowed, again, states or REIOs to use this, and we expect that mediations will be started in one of two ways. And I think this was actually a very good mechanism that, as we worked through it, we recognized, yes, we are starting to see more treaties that have a clause allowing you to opt for mediation, but it's certainly still a very small portion of the world. So how do you make sure that even if there's not such a clause, parties who want mediation can do it? So we have two ways basically into the new ICSID mediation rules, and one of them is the classic mediation clause in a treaty or in a contract, and one party invokes it and the other party agrees to go ahead. The other way that we are suggesting here essentially is that if the two parties, or even if one party thinks, let's give this a try at mediation, they will basically send a notice to the Secretariat. We will take that and give it to the other party, and it will be like a de novo offer to mediate. And if the other party is agreeable, then the process will unfold from there. So there's really two sort of windows into these new rules. The process is confidential, and all of the process and all of the architecture of the process really is geared to encouraging the use of mediation. So we have all of these sort of, the information gained is without prejudice, that you cannot repeat or otherwise use settlement offers, admissions, that kind of thing. We have a default to a single mediator, but parties can have co-mediators if they want. The only qualification for an arbitrator for a mediator that we have put in is impartial and independent. And if parties feel they want specialist qualifications, again, parties are able to do that in this context. And the only goal really is finding a mutually acceptable resolution. We have this mechanism again of the first session requiring a representative from each side to say, I have authority to resolve and I have a concrete mechanism in order to do what's needed to get to a final resolution. Throughout the process, the mediator obviously can request any kind of information, and the parties have a duty to cooperate. The mediator can caucus with the parties, so talk to them individually, go back and forth, whatever is most useful. If the parties request at any stage, the mediator can make oral recommendations or written recommendations to them. And again, we believe that if you end up with a written settlement out of your mediation, this will be able to be enforced under the Singapore Convention or potentially put into an ICSID Convention award using that mechanism. In terms of mediator liability, because this is not an ICSID Convention process, we had to grapple with the idea of what do you do? How do you ensure liability and those kinds of issues? So we have put in a clause in Regulation 13 that essentially, first of all, has an obligation that the parties and the mediators agree in the beginning that the mediator shall not give testimony in any judicial, arbitral, or similar process concerning any aspect of the mediation. And then the flip side of this, which is, except to the extent that such limitation of liability is prohibited by applicable law, no mediator shall be liable for any act or omission in connection with the exercise of their functions in the mediation, unless there is fraudulent or willful misconduct. So again, trying to build into the consent part of this process a little bit of liability protection so that people would not decline, frankly, to be mediators in this kind of a process. So all of that is a little bit of a description of what we are looking for. And what I wanted to move to and to close with, frankly, is a bit about how do we make these into success stories. Obviously, offering these rules is a first step and a good step, and there is a lot of enthusiasm, even if there's not a lot of concrete experience in investor state. But I think as a community that's involved in dispute resolution, we really want to think through how do we set these up for success. So I have a number of ideas and thoughts, and I'd be really grateful for your thoughts on this. In no particular order, my first one is that I think it is a huge mistake to think of these as glorified settlement negotiations. And I know that I have been in several investor state negotiations as counsel, and you really would not know the difference from an accident hit and run. I'll offer you 100,000. Well, how about 50? Let's split the baby. And I think that really does not mine the potential for mediation. So I'm hoping that we don't sort of default to that kind of thinking and really use these tools creatively. Secondly, I think these are very specific skills. They are skills that not everyone has, and when they are used well, they are a thing of beauty to behold. But we certainly need to increase the number of people who are able to mediate this kind of dispute. And I see that starting, and it's something we have to keep building on. We also have the related question of, do you take mediators and teach them investor state, or do you take investor state lawyers and teach them mediation? And it really is a bit of a chicken and egg debate, and I do not know what the right answer is, if there is one. I know we have started doing training with people to try and pull together the two contexts, and that's certainly something that's important to do, and we've got to keep doing a lot of that training to get ourselves to a state where we have enough people who are good at this and who start getting the experience. Fourth, I think we have to remember that with investor state, we always start with a bit of a different situation than in many other commercial disputes. You start with a situation where there has been extensive discussion between the disputing parties. They have probably been to their government at some point as the dispute has heated up. They have probably been to their embassies and tried to get their embassies to help resolve the dispute. They may well have been through some kind of a treaty consultation or an informal consultation. And I think this is a really important thing to remember because, quite frankly, at least in investor state, if there's such a thing as low-hanging fruit for resolution, a lot of that will have been picked up in that, consultation with embassies or consultations generally between the parties. So one of the things that we need to really think about is there still a real viable possibility of using this mechanism? And at times I've often thought, and I don't know how you would do it, but what might be a real benefit and what might ensure success is that we have some kind of a way to say, here's a dispute where the parties are just intractably at opposite ends, or one party realistically just couldn't or wouldn't resolve it, and let's not spend the time and money on mediation because it will be for naught. And the key will be, how do you figure out those cases where there's a viable possibility so that the system can work its magic? And I don't know who would be sort of the traffic cop who would be able to decide that, but I do think it would be a useful role if somebody could deal with it. Another sort of set of thoughts on recognizing the barriers is first that I think governments certainly need to get their hands around mediation, around these alternate mechanisms, and make sure that they have a position on it and a willingness to do this before disputes come up. And a number of government departments in their regular litigation have taken the position that we will always try to use alternate dispute resolution. Something like that kind of a commitment is a really good thing, and I know certainly the CERM project that Eloise was talking about is also talking to government people about, think about this, and this may be one of the things you consciously do want to add into your toolbox. Governments generally, I think, have a difficult role. They worry that if they mediate, they will start copycat cases, that it will look like they are too willing to compromise too quickly, or that it shows some kind of weakness, or if they think a case is particularly difficult, maybe it's best to just let the next guy do it a year or two from now. So there are some very specific, difficult hurdles for government, and we need to get around that. The other one that's been mentioned, which is very real, is the concern of a government official who is resolving or settling a case and then turns out to be told that this was due to corruption or lack of authority or fraud. It's obviously a horrible position to be in, and if it's not addressed in advance, it would be the very brave civil servant who launched ahead knowing that that might come up later. So that is one of those things that I think it's really important for government to look to and to address again in advance of all of these rules. So those are a few of the thoughts that I had in terms of how we can make this more effective and changing mindsets to say this may actually be a way to do what we want to do: retain investment, attract investment, and expand investment. I think we've seen a lot of governments who are ready to do this. And one of the things we are now telling them is that not just for arbitration, but for ADR, you need to very quickly get on top of your case. On the flip side of it, as counsel for a claimant, I think one of the things to think about flexibly is that sometimes a government at the beginning does not feel they're on top of their case. They don't know the facts, they don't know the witnesses. But if you were willing to mediate a little bit later in time, you might well have the opportunity to do something that's very flexible. So this idea about being able to use it at different times, I think, is really, really important. As a community, we will need to think through our position on transparency. And I have to say that just my gut feeling is this should be confidential if we really want it to work, but I totally take the points about here we are trying to make investor state more transparent. It does seem a little bit of an oxymoron that in this context, we're actually trying to go back to confidentiality. So it's something to work ourselves through. In these ICSID rules, we put forward a situation where it is a confidential process, and the only thing that we memorialized as public is the fact that you have in the past or that you are in the course of mediating. So it's right now pitched at relatively little transparency, but the parties again can make it the transparency level that they wish. So that's a bit of a description of the processes that we are proposing and also some of the challenges that we see as we implement this. We are very hopeful that by the end of 2020, we will have our new rules adopted by the member states with implementation in early 2021. So once this is done, I very much look forward to working with you and with the legal community to ensure that we get some success stories here, that we let everybody know about these success stories, and that we really sort of mine these tools where they can be of benefit to the parties. So with that, I pass to my colleagues.
Meg, thank you very much indeed. It's a privilege actually to be able to hear you explaining from your experience and from your perspective some of these important issues and how you see they're going to pan out. So I think we're very privileged, all of us, to have heard that. I'm going to move straight on. I'm going to try and make sure that we've left some time for comments and questions. So I'm not going to, as I say, introduce the individual speakers. Their CVs are in the brochure. Let me start with Arne Fuchs, please, of McDermott, Will, and Emery to speak to us.
Thank you. One of the reoccurring themes to me that is very important, that evolved today without coordinating amongst panels or amongst ourselves, it seems to be that in order to make any of these non-arbitration ADR tools successful, you not just need to put into practice a functioning, efficient procedure framework, what would be at the core of your task as an institution, but that you need a broader cultural change, both for the investor side and for the state side, and that is acceptance, not just in general, but also in the specific case at hand. Because if we talk about it like this, about alternative tools that could potentially provide a faster resolution, a cheaper resolution, a settlement that benefits everybody, everybody's on board. But things change very quickly if you then talk about your specific case. If you are the investor who's faced with uncertainty, what is the outcome of that mediation route, of that alternative tool that I'm using? Will it actually make the process shorter? Will I get a good result? Or will it just add on to the overall duration? Will it add on to the cost? And Melita spoke earlier about the many concerns that are involved there. That, in my opinion, to make it a high threshold for an investor to say, there's uncertainty, yet I want to go down this route. And one of the last things that you said is a good advertisement. Again, that is probably a chicken and egg problem that would need successful cases to spread amongst the community to say, yes, we have taken this risk and it was actually worth it. So go try yourself in your specific case. And likewise, for the state side, the discussions that we see in Working Group 3, in the arbitration rule revision context in general, everybody seems to agree that is a good tool to have, or it's good to have alternative tools. Yet when it then comes to the specific arbitration again, there's very basic elements of human psychology involved, that if you are the civil servant who has to step up and say, yes, I have full authority to agree to something here, and that will be my decision, that's a hard decision to make. And we've seen it in the system today over and over again, 3 months, 6 months cooling off periods that are not even attempted to be used, where not a single word is exchanged, or an objection on the 6th contingency level that's being raised that doesn't have any realistic chance of success. But when you think about it, it's much easier to defend later on, having taken that position, than having to defend a assessment that you made, that you anticipated that this objection would not be successful, and therefore did not raise it. Even in only a parliamentary inquiry, we don't need to go into criminal proceedings or other non-rule of law states. Such a question can be decisive for a civil servant. It is one thing to send a cooling off letter, a couple of €1,000, maybe even credited if the arbitration is started. It is another thing to actually start the arbitration. Do you want to be the civil servant who, without a specific arbitration being pending, says, well, I anticipated that the arbitration would be filed, that the investor spends all that money. I anticipated that then we lose, so I entered into negotiations. I entered into the mediation process, and I agreed to something. And I struggle to see, especially in today's climate, how you can bring about such a fundamental cultural change on both sides. And I would be very interested, Meg, if that's something, because it goes beyond your core role as an institution. Is that discussions that you also have with state representatives? What is the feedback that you get, and are you more optimistic?
I get huge enthusiasm from states, and the real question is how big a gap is there between enthusiasm and making it happen? That's the key.
Exactly, the specific case. That's
Donna, you're pointing to the reluctance of a civil servant to commit, to take the responsibility for an agreement which may be criticised later. Do you see any solution to that?
So I thought about this. What would you need? You would need a clear guarantee. Would I, if I put myself in the shoes, would I rely on a general policy statement that we heard about earlier, that we include policy statements saying we want to favor mediation, we support mediation? Would that be enough for me? I would probably still be very reluctant.
You still got it wrong. You still paid too much money.
Exactly.
You still gave away the crown jewels.
Without being ordered to do so by a tribunal. And that's the comforting position that I have, right? If I lose, I have a bad tribunal to blame that didn't get the objection, that didn't get the law. I fought it vehemently. I didn't succeed, but I tried everything rather than giving it up voluntarily. And that's why I'm saying this is basic psychology where I think we may hit a border. And it's not just the civil servant, the same for the investor. I spend literally years writing memoranda, answering questions from the board. What will happen at this specific step of the arbitration? How much time will it take? How many hours are you going to charge me for this? What is it going to cost me? And this is to, in the end, get a binding resolution. Now, if you add to that the uncertainty of, well, do we also want to try one of these new tools that we don't really know yet and that are uncertain? That doesn't make it easier.
Can I ask, Meg, before we move on to Stefan, you drew attention to the fact that in the period there have actually been very, very few conciliations, even though that's been permissible, and no fact findings.
Exactly.
What do you attribute that to? Do you know, I mean, has any research been done or investigation as to what the cause of that is?
I haven't seen research on that. My guess would be it's attributable to the fact that by the time people have tried informally these kinds of mechanisms, they've realized it's not working, so they just put those mechanisms aside and say, let's arbitrate to the bitter end. I think that would be my sense of it. And often people come to investor-state dispute settlement and their idea simply is, let me get financial remuneration for the damages I've suffered. In many ways, the treaties are set up for pecuniary remuneration. They're not set up for creative, geez, how can we get you back into the country?
Right.
Could we give you the concession? So in many ways, I think we've structured this so that we think about arbitration as the final resort, and by then we don't think about other options. And it goes back to, as you say, a bit the culture and trying to make sure governments know the cost benefit, the enforceability, but also the positive side of keep that investor in your state. If they're in your state, we know they're probably going to expand, and this is what you want. So going back to showing the positive benefits, so it's worth taking a bit of a flyer on it, in a well-considered way.
Yeah. And I mean, maybe that could be one of the selling points, one of the PR levers that you have, that you say, well, you can talk about not just money, but actually getting your concession back or something alike. But then again, today's climate, imagine a setting where you have a measure that revoked a concession for environmental reasons, even if in the end not upheld, found to be in violation, and you agreed to granting that concession again, or some other sort.
Well, if the reason was for removing the concession was environmental, it may be particularly sensitive to put it back in, but there are lots of other reasons. People say they've removed concessions.
So
they
the
may be
alleged
less-
reason even.
Less sensitive. Stefan, let me bring you in at this point.
Yeah, so thanks a lot, and thanks to the organizers. Looking at the program today, I think maybe a name change is in order from the European Federation of Investment Law and Arbitration towards European Federation for Investment Law and Dispute Settlement. And the acronym would then be EFILA. Now, I want to talk a bit about the challenges of ADR in investor-state cases and emphasize the importance of public law and policy in that respect. The first point, I think that the time is really ripe for thinking and also promoting ADR in an ISDS case, and I think ICSID does that very well. And the time is ripe for the precise reason that I think by now we are in a context where the system of investor-state dispute settlement, particularly under investment treaties, has really matured. There's much more clarity today about the standards that govern investor-state relations under public international law and also under standardized contract as compared to, let's say, 20 years ago. And just think about what the discussions were around 2000s about the meaning of fair and equitable treatment and what they are today. So I think ADR in that context is really good to help settle disputes, but ADR really has to be thought as an alternative to an adjudicatory process. So without the existence of an adjudicatory process, I think thinking about ADR is difficult because the adjudicatory process does more than ADR. It settles the dispute, but it also helps clarify what exactly the law requires of the parties involved. And ADR does not serve that second goal. Now, ADR requires certainty, and that's the second point, as to the background legal framework against which the parties bargain. So ADR, in a sense, is bargaining against the shadow, or in the shadow of the law. You need to agree to ADR, and in the end, you need to agree to the result, and that, of course, depends on what the potential alternative in an adjudicatory process would be. In investor-state cases, I think this legal certainty about the legal background is so important because there's a public law and public international law framework that imposes obligations on the state and that defines what the fiduciary duties of the state vis-à-vis its constituencies are. And ADR, in a certain sense, can interfere with the checks and balances that a public law framework, a constitutional framework that states are subject to imposes. So there are, I think, specific risks of ADR in an investor-state context that we don't find in the same way in private dispute settlement and ADR. And the core question that I think we also need to ask is, how do we ensure that ADR does not negatively affect the public interest? What are the specific public law limitations that we're facing? So I think that the risk stated at its most general level is that, of course, ADR can risk contracting out of certain public law strictures, out of the checks and balances that exist at the domestic level. Using ADR to cover corruption would be just one very extreme case, but I think there are others, circumvention of procurement rules, so on and so forth, budgetary rules. So I think that's something we need to think about, and I think that leads to the question, who actually controls that ADR with the involvement of the state is not used to contract out of certain public law strictures, that it isn't used to create a black hole where there really is no control. So I think that's the contrary, the opposite side of a public official saying it's too risky for me to agree to something. Well, there's also the risk that maybe there's too much agreement and too much negotiation and too much concession being made also on the side of the state. And I think that leads us to the last question: what kind of control mechanisms for ADR in investor-state cases can we think of? What kind of control mechanisms do we need? And I think there are four things that one should think about. So the first one is transparency. Would it work in an ADR context? It's one of the things that discussions over many decades have brought us to, that it's something that works relatively well in the investor-state arbitration context. For the ADR context, I'm not so sure. But I think what certainly is important is that we have clear domestic legal frameworks that tell the state and its officials under what conditions settlements agreeing to ADR is possible and under which conditions it isn't. So that's, I think, the mirror side of actually having authority at the international level of agreeing to a settlement, while I think then also is a need for a domestic law framework that tells public officials under which conditions they can exercise that international authority. Finally, I think we need to start thinking about certain red lines. So can we think about ADR and then a settlement agreement in cases where the potential source of liability of the state is legislative action? So can we think, for instance, of a settlement in the Vattenfall case where the German government would agree to reintroduce nuclear power without asking the parliament? So I think there's much work to be done to thinking about what kind of cases are actually apt to be settled and to be channeled into an ADR procedure. And finally, I think we need to start thinking also about the role of the mediator or the conciliator as somebody who's not only trying to reach a settlement, but also who's somebody who tries to pay attention that these public law strictures are actually abided by. And I think that's something which then also has to do with a cultural and mindset change. When you think about the individuals doing that, I think one does not only need mediation skills and knowledge about investor-state treaty law, but I think one also needs knowledge about what exactly are the public law strictures that specific state is subject to that you're dealing with. So these are my 5 cents.
Right, well, they're a very valuable 5 cents, but they're quite a frightening 5 cents. Because you're sort of saying at some point, even if the investor and the state would like to reach an agreement to bring this to a dispute to an end, you shouldn't allow them to, because it's going to result in the law not being clear when there was an opportunity to do so, or something else. I mean, all lawyers who practice litigation are conscious of the problem that sometimes clients will settle where you were really hoping you get a great case in the Court of Appeal or the European Court or something of that sort. And I certainly still very angry with a client many, many years ago who settled a case which was going to be a really important one in Luxembourg. Would have solved a lot of problems, by the way, if that had gone on. But anyway, do you have any immediate observations, Meg, on this idea that somehow there should be some control, perhaps, in the way that ADR mechanisms are allowed to be used?
I guess the control is really if the two parties, including a respondent state who is there for the benefit of the populace and not just a particular interest, if the two parties are satisfied with a resolution, you hope that those kinds of checks and balances have been brought in. There is also the question about sort of third parties. And I mean, you don't want to make this into a huge royal inquiry or anything like that. I do understand that. But we've seen in the environmental context very good use of mediation where they have been able to bring in, for example, I know in Canada, electric projects, and it goes over Aboriginal land, and you've got multiple interests, and then you've got environmental interest. So it is a tool, I think, that's able to do that at least probably better than arbitration itself. So complicated, but maybe it's still the right tool.
What I'm going to do, we've still got two of our commentators to intervene, but I'm going to suggest we spend a few minutes taking some interventions, questions or comments from the floor. So I'm going to ask you to put your hands up. When you do speak, I don't know whether you've got microphones, so shout. When you do speak, someone's stood up, probably haven't. But when you do you mind just saying who you are? Many of us may know you, but it'd be good just for everyone to do so. So who's going to be first? I see a hand at the back, so you will have to shout. Please, yes.
I'm going to add a frightening question to 5 sentences by Stephen, and I may annoy Nico.
You can now make it loud.
All right. Should I repeat? Or I might be even more frightening in that case. My question is, and the reason why I would be possibly annoying the division of labor and subjects organized by Nico is not to mention ACMEA, but I mean, we're talking about alternative dispute resolution, which means that the law, possibly including European Union law, might be a factor, but not one which an adjudicator would interpret and apply at variance with what might be the exclusive competence of the European Court of Justice. But from experience in environmental law, in the process in which I have been involved, at some point, the European Commission said that treaty bodies, which are by definition, self-definition at least, non-adversarial, non-adjudicative, in applying European Union-related, considering as a factor European Union-related law would impinge upon the exclusive competence of the European Court of Justice. And in that case, the states parties to that treaty, and the majority of states parties are European Union member states, would strongly be discouraged from applying to such mechanisms or even accepting to being referred to such mechanisms. So my questions is addressed to those European Union expert lawyers, whether this would apply also with regard to alternative dispute resolution mechanisms here, And the policy consideration is whether this would not really have some kind of a chilling effect on states, parties to these disputes, towards such very nice mechanisms.
Thank you.
And I hope we can all agree on some way to go about it.
Thank you. Let's take a couple more observations and see if anyone wants to answer that question. Lucas.
Lucas Mistelis, I take a bit an issue of something Arne has said, that effectively it might be very difficult for a particular government official that has to make a decision to mediate or to settle a mediation. I think what history suggests is that this can only work if it's not an individual make a decision. For example, if my recollection is correct, about 6 or 7 years ago, Egypt settled a very large number of cases. But this was not a decision taken by an individual, but a decision taken by an interministerial committee that collectively decided it was better to close 10 cases rather than to keep them open. So, and I think that's something, for example, that needs to be encouraged. It's perhaps something of the work that Elodie is going to, Reis is going to be doing with her team, and understanding that disputes have permutations which are beyond the legal fees and the legal costs, and it's a collective decision of the government.
Yeah. Do you understand me, Mike?
Yeah, absolutely, 100%, that's right.
Okay. Let's take a couple more questions, please. Yeah.
We have a mic.
Right next to
Great,
you.
Great, thanks. Perfect. Right, it's behind you. Great. Thanks, Peter. Gordon Nardell, barrister at 20 Essex Chambers. I realise the topic of conflicts in the context of mediation and arbitral tribunals was raised in the last session, but I'd like to ask a question revisiting that topic here. We know there are various ways, two main ways, in which a binding dispute resolution system can encourage parties who are already in that system or contemplating using that system into ADR or mediation. One is at a high level in the rules of procedure of the dispute resolution system, such as rules of court, which can impose certain adverse consequences for parties who don't look seriously at mediation. The rules can gently or not so gently steer a party towards mediation, or, and this is of greater sensitivity, the decision maker, the judge or tribunal, can gently or possibly not so gently steer the parties towards mediation. I'd quite like to, and I think this is mostly a question to Meg, but the others may have a view. Is it appropriate in investor-state arbitration for a tribunal ever to express the view that actually it would be a jolly good idea if the parties were to take time out of the formal process and consider mediation? And if it is a good idea, should there be cover in the new rules? So in other words, should there be an interplay between the formal ICSID rules for arbitration and the rules that are being developed for mediation to allow tribunals that possibility and give them cover to legitimise the practice if it's considered appropriate? Thanks.
A mandatory requirement is the best cover of all, of course. Meg.
I don't know if they need cover. I've seen this happen in practice, and I think they'll say it in a particular way, and if one party is obviously not inclined to the idea, they'll know how far to push it. I understand the point about pushing it to the end, but I'm not sure that they even need some kind of extra cover, I have to say. I don't know. I'd be curious what others think, but I've seen arbitrators do that pretty frequently, especially when you get to the end of the merit session and it's, don't you really want to go and talk about where you go from here? Do you really want to be with me for another 3 years or whatever, you know? So I think it does happen, and I'm not sure more cover is needed.
Okay. Let me go to Monty now, and then to Pascalis, and then we'll take some more questions and interventions after that. Monty. He says it's you next.
Sure. No, I was just wondering whether we would have an opportunity to deal with some of the other questions that came from the floor, because I wanted to pick up on something that Lucas had said, but we can defer to your chair.
You have the mics.
I have the microphone, so you have to listen to me. I have the unenviable task of delving into Meg's perfectly drafted rules and to speak a little bit more about some of the issues that were discussed in the last panel, but I'll try to add my spin on them. In particular, I wanted to start off by discussing the gateway in terms of relating to an investment. And whilst that, of course, is a much lower bar than you see in Article 25.1 of the Convention, as soon as I see the word investment, alarm bells go off, and I start thinking of if you are or attempting to kick off a consensual process, and let's say we're not talking about a pre-existing consensual agreement in a treaty, for example, but rather trying to make an ad hoc agreement after the fact, I imagine it could be difficult to convince a client to consensually move forward with a process where they might be implicitly agreeing that this particular issue relates to an investment. I imagine that it would become a practical issue more than an actual obstacle, because you could do something similar to what we see in the Article 25.1 context, where a state may well send a letter saying this is all rubbish and you shouldn't, of course, register this request, but then using the Article 36.3 screening mechanism, the Secretariat will still register the request without prejudice to that objection. Of course, it's slightly different in the context of mediation, because that objection would never be ruled upon, and it's not the best way to start off a consensual process with an objection to the jurisdiction of that mediator or the centre in that particular point. But turning to a couple of points about transparency, which has been spoken about a fair bit today already, so I'll keep my comments brief, but I have found it quite a fascinating interplay watching this dynamic between confidentiality and transparency, both of which are of course extremely important respectively in the context of mediation and then in investor-state dispute settlement generally. And we've seen some varying approaches to this in various soft law instruments, but also in treaties, with the EU taking a stronger line towards transparency in the EU-Singapore IPA and the EU-Vietnam IPA, where not only is the fact of the mediation not confidential, but at least in the case of the Singapore IPA, the settlement itself shall become public. So that's a much stronger direction towards transparency than we've seen elsewhere. Of course, in the IBA rules, there are similar mechanisms in place, although it's not written in the same mandatory language, but certainly the outcome, if a settlement is reached, is not confidential per se. As Meg mentioned, ICSID has taken a more flexible approach, and I think it's fair to say it's consistent with the approach to transparency within arbitration, has left it for the parties to make that decision on a case-by-case basis. And I think that's sensible for a few reasons, because the interplay between transparency and enforcement, for example, or interplay between transparency and the ways in which a state official, for example, might deal with that mediation are important. So we've spoken a bit about the state official that may have to make that call within the room, and this is bolting on to what Anna and Lucas were speaking about. But that's a difficult position to be in, and as Meg has mentioned, you actually have to identify a representative who has that authority. So if you're in a position where you know that the outcome is going to become public, or if you're in a position where you know the outcome may become public, that could potentially disincentivize getting to that point of settlement. Of course, the transparency of the rules, or what is baked into the procedure, may not have that much of an impact in any event, because if you're looking to enforce in other jurisdictions, or even if you have to seek approval within your government, that may still become public. So I think the problem probably exists regardless of whether it's in the rules or not. But the other point I wanted to mention about confidentiality comes to is in the context of enforcement. And Meg has set out that there is a possibility for both Article 54 style enforcement of settlement agreements out of mediation, or using the Singapore Convention. Now, the Singapore Convention has some very interesting challenges to enforceability. And a couple of them I just wanted to flag in Article 5.1. So if you're seeking to resist the enforcement of a mediated settlement agreement, a party that's trying to do that can furnish proof, or they can attempt to resist by furnishing proof that the mediator committed a serious breach of applicable standards that led to the party entering into that settlement, or that the mediator did not disclose a conflict that also led to that party entering into the settlement. Now, to my thinking, those are grounds that would require some trespass into what occurred within the mediation. Not necessarily the conflict itself or the breach itself, but how it impacted upon the party that made the decision to enter into the settlement. And if you have a look at the way in which the rules are currently drafted, at least in the ICSID context, you have a reference to, I believe it's if required by law, the settlement or the aspects of the mediation can be disclosed. But then we get into this discussion as to whether, if you're seeking to overturn or seeking to resist enforcement of a settlement agreement, is that required by law, or is that as necessary to pursue or protect a legal right? So you have these interesting issues that are going to pop up when you line up a set of rules with a convention, and you have all the various concerns and dynamics that went into creating that convention, but you also have distinct, potentially, concerns and dynamics that went into the ICSID rules. And when it comes to the point of actual enforcement, how will that play out? And I'm sure a practical solution will be reached, but you can see that there'll be teething issues, at least in the first instance.
Okay, thank you. Pascalis, why not turn to you, and then I'm going to ask members of our colleagues to raise points.
Thank you very much. What I was thinking of doing was to try and link this discussion with the overall theme of the conference, which is the alternatives to intra-EU BITs, which are about to be terminated. But first of all, I would like to make two very brief comments. I think a lot of this discussion about ADR and reform and so on completely discounts a very key element, which is politics. And a lot of people said the civil servant, the civil servant, the civil servant. As a former civil servant, I can tell you it won't be the civil servant, it will be a minister. And a minister has an investment that has to pay back on a weekly basis, and not like an investment that will have to pay back in 10 years' time. So this is a massive discount. And the second thing that is being discounted is that everybody assumes that people act rationally, whereas in fact they don't.
You're talking about politicians again, aren't you?
As well. And the second big problem with mediation and all these alternatives that basically create customized solutions, at least in the EU, is that you're now in the minefield of state aid, because you will be creating advantages specifically negotiated for a specific undertaking. It will be selective. Normally it will be through state resources, and automatically this ill-conceived bilateral relation between the state and the investor actually will become trilateral, because you will have the European Commission involved. And if we start giving examples of states promising, as the French would say, n'importe quoi to investors, and investors accepting that, I mean, we will be here until dawn. And one of these examples, which is very sad on both sides, is the Spanish ECT cases, which basically leads me to my second point, which is I think in the context of the EU, we have to look at the big picture in terms of economic and political reality before, as an investor or investment arbitration community, we start making requests. And the first element of that big picture is that the WTO system is broken and nobody's fixing it. And today, a German investor in Greece is not really competing against a French investor. In fact, they're competing against a Chinese investor. The Chinese have been making, for example, significant investments in strategic assets in Europe. You only need to take the report that comes with the latest EU regulation on screening of foreign direct investment to see that, for example, sovereign investment from the UEA has risen from 0 in 2007 to 250 billion euros in 2017. So in many cases, let's say the hypothetical Chinese investor will benefit from a state subsidy that will allow them to pay an enormous amount of money for an asset located within the EU, whereas no other EU investor will be able to put the same amount of money on the table. State aid is in principle prohibited in the EU. That intra-EU BITs are terminated. There is an asymmetry of remedies because the Chinese investor will continue to benefit from actually what I understand to be a rather aggressive BIT policy on behalf of China, and will have access to arbitration. And then the EU investors will have what? Will have like ADR. You know, it's like they have the nuclear bomb and we have aspirin, you know, that kind of scenario. So I think ADR, I mean, I don't want to regulate. I believe it's important, but it's a carrot and stick thing. You can't be waving just the carrot. There has to be a stick somewhere in all of this. And I understand that at least the Commission is seized of this problem about the future of intra-EU investment in the 21st century, and they are considering a number of alternatives. Now, the problem with some of these alternatives is that they are exactly soft tools, and the flagship being a mechanism so-called Solvit. Now, Solvit is essentially designed for citizens who can't get paperwork done, you want a VAT refund as a small and medium-sized business and so on, they will not be able to solve issues for big investment, which is necessary in 21st century Europe. You know, when we're signing the Paris Accord on one hand, we want to have 35% green-sourced energy by 2035, I think, which requires a massive investment in infrastructure on solar panels. And that money will, and a solar panel is essentially an investment which is expensive to make and very cheap to maintain. But investors, in order to put that money in the solar panel, they have to have some assurance that the money will be recouped at the end of the investment. Spain, for example, in that specific context, had a very nice slogan campaign, the sun is all yours and the premium is so high. In the end of the day, it created a massive deficit. And when the crisis hit Spain, the consumer, who was meant to be paying the cost of the system, was not paying the bill anymore. And of course, the Treasury will go back on the promise. I mean, money doesn't grow on trees, even when you come from Greece, when it comes from Germany. So I understand that the investor community has been very upset about a lot of these developments, but the viewpoint of the state cannot be completely forgotten, especially because it is deeply political. And I think that is something that has to be borne into mind. And now that the Commission has making, this initiative they're calling it the workshops, and there will be another one coming up, we have to attend, because if we don't, then there won't be a future for investment protection in Europe. And this is my last remark. I notice very often that when we start, investment arbitration attracted a lot of criticism over the past few years. I don't care whether it is right or wrong, but it did. It seems to me that the people thought that the alternative is to informalize the process. And that is correct. That is one of the alternatives. The other alternative is to formalize the process even more and turn it into a court, which will meet certain criticisms, mostly from civil society. And, perception of justice is as important as the actual justice. And for me, I think what we need, at least on an intra-EU level, this idea of a multilateral court, investment court, is even more necessary intra-EU than it is extra-EU. And I will finish on this.
I wonder if the court might think it's that already, but anyway. Thank you very much indeed. Let's take some interventions, please, from from our colleagues in the audience. Who'd like to raise a over there, please? Let's have a...
Thank you. Nicolas Angelet. I have a question on an issue that was discussed before by Meg, which consists in attaching a mediation or conciliation report to an exit award and then have it benefit the specific advantages of recognition and enforcement of exit awards. The specific advantages under exit Article 54 are specific to pecuniary obligations. On the other hand, I think typically a mediation or conciliation report may contain pecuniary and non-pecuniary obligations and obligations for both parties. And these, I think, would by nature be an indivisible whole. It's a package deal. And does that not raise the question of whether it is possible, and if so, advisable, to do the operation to the benefits of the pecuniary obligations and to the detriment of the package deal? Thank you.
Yeah, that's interesting. I guess my gut reaction as a council would be I'd rather have it than not. Maybe it just applies to the pecuniary side of the award, but I'd rather have that security, at least with respect to the pecuniary payments.
Just to jump in here, of course, many exit awards do include non-pecuniary obligations within the dispositif, and having been on the benefited from awards that included that mix, I can agree with Meg that as long as an aspect of it is enforceable obviously under Article 54.1, then you're in a better position. But from my perspective, I would imagine that the difficulty that comes with the mediated settlement agreements is that in order to have a settlement agreement converted into an award, it requires the consent of both parties. And if you have paid a certain amount or made a promise to another party, I can't imagine that I would be advising that client to convert that convert that settlement agreement into a much more enforceable instrument using Article 54 rather than the still as yet unratified Singapore Convention.
Question at the back, please.
I'm John Laird from Crowell and Mooring, and I have pretty much a direct follow-up to that. And I would like to ask if I'm irretrievably stupid, and especially having a former Attorney General in the building as well, that even going further than just saying Article 54 and the pecuniary obligations, and I'm going back to what Meg was saying earlier about trying to be more creative than how about 100,000, how about 50,000, let's meet in the middle. Is there something fundamental that you would all generally tend to believe, and even with the difficulties of what you've been going through in producing these new ideas, that indeed not just Article 54 only pecuniary obligations, but in general, as I understand it, like for example in the Crown Proceedings Act in this country, you'd be taking anything that you would turn into an award, whether you try to turn it into something under ICSID or New York instead, or Singapore if it gets any serious ratification. And if you had a recalcitrant state, that their own courts would simply not be in a position to help you. And in that circumstance, does that make something qualitatively different about trying to do something other than a pecuniary, settlement for an investor, different from commercial circumstances that, without something else being done about how states view their own immunity about injunctions and other actions, it's simply never going to be able to be sensibly more than pecuniary.
Thanks for the question. Meg, do you have any comment on that? Or anyone else on the panel?
No, it isn't.
Monty?
Okay. I think I would just briefly say that I think it's fair to say that depending upon how creative the solution is within the mediated settlement agreement, there will be difficulties in relation to enforcement. For example, if it's about allowing a license or some sort of incentive, because how would you enforce that even in the courts of that state? But you just have to hope that that through the consensual process that led to the mediation, you would have a state that would comply with it. But I take your point that enforcement would be difficult, if not impossible.
Other questions or interventions, please?
Maybe I can take the opportunity to comment on something that Pascal has said, and that's that the perception of justice as important as justice itself, and put it together with another thing that you brought up, and that's Solvit, the flagship EU model, and share an anecdote on Solvit. If you know the German legal system, you know that you have law school, you have a first exam, then you have 2 years of mandatory practical training and a second exam. And during those 2 years of mandatory practical training, you go through different stages, if you so will. Some as long as 3 months with administrative bodies, which can be ministries. And one of the very popular places to go is the place that actually handles the Solvit requests. So, in fact, what you have there is a department that has one permanent civil servant heading it, and 2 or 3 stagiaires joining for 3 months, handling requests for conciliation that come in. So, with that, to achieve a resolution of even a very, very low-level investment dispute, as a matter of fact,
they don't even have the. I would use the word jurisdiction in the very broad sense to deal with expropriation.
Exactly.
They can't.
Something comes in, you make a few phone calls.
Not even, because, yes, but you would be doing that, let's say, one of I think from the cases they have dealt with, the one that comes closest to investment dispute is a case about access to a river for rafting companies, which was more expensive in Slovenia when you were not a Slovenian company. So that was resolved. But between that and your typical investment case, there is, it's a big distance. And because you're going, actually what the principle of Solvit is, you have the home state and the receiving state.
Exactly.
Basically, it's kind of diplomatic protection revisited. Well, the two states come together and try to find a solution. And of course, they can't deal with expropriation because they never had a judicial decision telling them this was expropriation and in fact an unlawful.
Solvit doesn't allow for compensation, does it? It's
Exactly. So
solutions.
they can't deal with expropriation.
Can't deal with it. Stefan, you wanted to come in.
Yeah, so one comment on the question about pecuniary obligations and settlement. I think a good settlement agreement takes account of the contingencies of enforcement or non-enforcement. So that's something for the contract lawyers to do. You have to think about the enforcement of the obligations that you included in a settlement agreement, and you should make contractual provisions for non-enforcement, which then are pecuniary, and then solution around the problem. I wanted to also briefly respond to Attila. I think Pascale's presentation gave a very good example of the additional complications that member states of the EU have. They have a public law of their own plus EU law, and both have to be satisfied in order for ADR to actually work in the field. And I think that just reinforces the point I tried to make. If you're thinking about enhancing ADR in the investor state context at the international level, this will only work not only if you provide procedures internationally, but if that process goes hand in hand with a discussion at the domestic level about creating a domestic framework that actually opens up and enables settlement at the domestic level. So this is a process that needs to go hand in hand. If we start working just at the international level and forget about the debates at the administrative law level, at the constitutional law level, you will get nowhere. And I think that's a challenge because this community here is somewhat isolated from the debates in the public law context at the domestic level. But that needs to take place.
Look, one thing that was made very clear to me by Nikos was that I had to keep the time clear and precise. And we're coming to the end of this session. So what I want to do is to thank you very much indeed for participating. I hope that Meg will have got some useful insights into some of the problems she's going to face. And I hope it'll be helpful perhaps finding solutions to them. Can I ask you to show your appreciation in the usual way?
Thank you so much. Before you leave, we have a small intermezzo, so I would like you to sit down for 1 second. First of all, I want to thank both Meg and Lord Goldsmith and the whole panel. It was a personal honor to have you here. And I'm not sure about Stefan's suggestion. I was thinking maybe to add arbitration and mediation to EFILA, but I'm not so sure. The second thing I want to say is, and now I learned why I'm not rich, because my olive tree at home doesn't show any money. And the final thing is, even if arbitration is abolished, we all can become mediators. But what we want to do, and I would like to ask Lucas to come here, because we have developed together another baby. Because a lot of people ask, what are you doing with EFILA? Just spending money on parties? Yes, we do, and also on conferences. But we also have, this is the 4th issue of the European Investment Law and Arbitration Review, which Lucas and we are co-editors-in-chief. I guess it should be your must-read. Somebody told me it's all about Acmea. Well,
sometimes it is.
Yes, but not only, I can assure you. And we have a competition. Actually, we have a call for papers in general, and we have an essay competition for what we call now young practitioners. So we ask the young ones and the not so young ones to submit any unpublished materials that is related to this scope of this review, preferably by 1st of April. And the last competition was won by Sarah Arif. Please come forward, from Erasmus University, Rotterdam. Very well done. Well, we take a picture if you turn around. Well, we go in between, yes. So this is what all these who is who are saying. This is a future leader, right? So remember her name, remember her face. This is going to be a future leader. So give her an applause because she really deserves it.